Welcome to the Taxpayer Podcast, a podcast production by the Taxpayer. Each of our episodes is CPD certified. To claim your CPD points, please visit our website. For more informative discussion on tax law, please visit our website to learn more about the Taxpayer Journal.
Hello, Peter. It's always a pleasure to see your face beaming at me on my computer screen. And today is no exception. Welcome to our viewers and listeners, our putative viewers and listeners, but we really appreciate their comments when we get them. And it's always a pleasure to do this. Now, you've got a mystery topic for us today, Peter, so I'd love to know what.
I have a mystery topic, and we alluded to it on our last podcast when we were talking about production of income. And I said I'd love to talk a little bit about expenditure incurred in respect of interest on loans borrowed at the same time or round about the same time as the borrower is declaring a dividend. And so maybe to jump into that factual situation. So as we've said before, Section 24J is the appropriate section to look at here for the borrower. And the borrower must deduct the interest if it's incurred, firstly, in the production of income, and secondly, for the purpose of trade. And where you look at this factual scenario where a taxpayer company borrows money and declares a dividend at more or less the same time, the question there is whether the interest is incurred in the production of income. So that's what I'm going to focus on. So it's an area with a lot of case law, which is always worrying because it means that it's something that SARS are engaged with, and it's something that SARS are prepared to take to court. And the other interesting thing about the case law, Trevor, is that it's split 50-50 pretty much in terms of the big cases. So there are four sort of major cases in the area: Giuseppe Brollo and Ticton Timbers, which SARS won. And then there's Scribanti Construction and BP, which the taxpayer won in both cases. And all went different ways on very nuanced facts. So it is a tricky area of law/fact. So just to go back to the sort of the general principle obviously is if you borrow money in order to fund income earning activities like operating expenses, acquisition of trading stock, acquisition of productive assets, then the interest is deductible in terms of it is in the production of income. If you borrow money in order to declare a dividend, you don't get a deduction. Why not? Because the interest is not incurred in the production of income. And so the critical test here really is, what is the purpose of the borrowing? And this brings us, Trevor, to one of your favorite cases, which is Warner-Lambert, 2003 case. I think we talked about it in our last podcast. And just to again quote, where the court held there said, it's quite easy to mistake the purpose of an act for its consequences. The consequences of an act often proclaim its purpose. However, one must test the object, aim, and purpose of the taxpayer. And as we know, the test of a taxpayer's purpose is a subjective matter. We've said that many times in the context of anti-avoidance as well, as far as we're concerned. So you need to look at the borrower's purpose. And there's lots of ITC and other authority on, you must look at the taxpayer's purpose. That's the critical aspect which needs to be analyzed. Obviously, when you look at purpose, you look at all the facts and circumstances. You don't just look at the taxpayer's ipse dixit or what the taxpayer says it borrowed the money for. So you don't just look at the taxpayer's say so, you test that against the facts and the circumstances. So in the BP case, the question there was whether the company borrowed money in order to fund its income earning activities, or whether to pay a dividend, which was paid at around the time that it borrowed the money. And the critical part of that judgment, and to me, the critical part of all of these judgments, or if anyone's looking at doing these sorts of transactions, is the court said at the time that the dividend was declared, BP South Africa did not simultaneously have to borrow an amount to replace the dividend or any part thereof. So just to say that again, at the time that the money was borrowed, the relevant taxpayer, sorry, at the time the dividend was declared, the relevant taxpayer did not need to borrow an amount to replace the dividend or part thereof. And that goes to the interdependence issue between the dividend and the borrowing. So quite a tricky thing to kind of think about a little bit, because obviously if you declare a dividend, the cash has left the company, and that often means that the company needs funding. And how does it raise funding? Well, one way is to borrow money. But the key aspect here is to make sure there isn't an independence between the dividend and the borrowing. And what taxpayers often do in implementation is they set up two separate accounts, which I think is always a good idea to evidence their intention. So they set up a specific account into which the borrowed money comes in, and that's used for ring-fence purposes in order to, for example, acquire trading stock, fund operating expenses, buy productive assets. And then separately, there's what's called a collection account, into which excess or surplus cash moves. And it's from that account that the company then declares dividends. And to evidence your intention through this careful implementation of your funding account and your collection account. But the implementation is critical, as I said. There's lots of case law on this. Goes both ways. It's something SARS look at. It's quite sort of it's purpose driven, which is a factual test. And you have to look at the implementation of the arrangement, I think, very carefully. So, and as I say, just to make sure that at the time you declare the dividend, you don't need to simultaneously borrow so as to replace the dividend that's been declared. So see it a lot in practice where companies want to refinance, introduce borrowings, and it's a nice way to introduce some gearing or leverage into a legal entity, but needs to be done very carefully and very properly in order to avoid any nasty disputes with SARS. And I think just
Can I
yeah.
just say something sort of perhaps anecdotal about? I appeared in the Ticton Timbers case, and I used to say to people, sometimes you get those pictures. If you look at it one way, you see an ugly old witch, and if you look at it a different way, you see a beautiful young woman. That's what that case was like. It just depends on the way you see it. Because if a company, or in that case, a closed corporation, declares a dividend which is credited to the loan account, is the company paying a dividend and then borrowing it back? Or is the company not paying the dividend, i.e. it's keeping the money in the company because all it does is credit the loan account? And which way do you see it? My opponent in that case, I won't mention any names, but suffice it to say that he's a very, very highly esteemed constitutional court judge. So you know exactly how I'm
Never
talking
guessed that is.
He gave me an absolute trouncing, and I remember the case well. Was Dr. David Ticton he was a doctor, he had a PhD in history, but he was in the timber business. It was a family business, and but it was a one-person company, and he'd bought out his brothers and sisters, etc. And the issue came up, and it was Judge Horrams, not Horrams, Heerfer was the presiding judge. And I said to him, but you've got to look at Dr. Ticton's intention in his capacity as the director of the company, and distinguish that from his personal capacity. In his personal capacity, might have wanted the dividend, but as a member of the company, he wanted to keep the money in the coffers of the company, and therefore it was just so the company didn't part with any cash. And I suppose I set myself up for this, but Heffer said to me, but I was alive to the point. Heifer said to me, but Mr. Emslie, it was held in the Pick and Pay case that a man doesn't change his mind when he changes his hat. Now, that was said by Judge Nicholas in the Pick and Pay wholesalers case. And Heifer was one of the dissenting judges. So I thought I might get some for problem. And what I wanted to say, but lacked the courage to say, was say, my lord, in those days, I think we called SCA judges my lord. I can give you a perfect example from history. F.W. Rates, former president of the Free State and state secretary of the Transvaal during the Boer War. When the Boer War came to an end, he was part of the delegate that went at the Treaty of Vereniging, and he went to Pretoria and signed the peace agreement. But when it came to his personal capacity, because each person who'd fought had to sign that they would abide by the peace terms, he refused to sign and he went into exile. There's an example of someone who did one thing in his official capacity and one thing in his personal capacity. Anyway, I'll finish talking now by saying one thing. The esteemed judge that I'm talking about was involved in other cases. And he didn't say this to me, but it was reported back to me that after the Scribante cases and things like that, he sort of said musingly, he thinks maybe Ticton Timber was wrongly decided. That was one of the finer compliments I've received. It didn't change the outcome. Anyway, I'm sorry I'm interrupting you.
No, in fact, Trevor, you were missing from the BP case. You were kind of the only one missing because that was fascinating because Dennis Davis was on the bench in the tax court. And then for the taxpayer, for BP, was the esteemed judge.
Yeah.
And he was junior to Meyerowitz. And on the other side, acting for SARS, which is unusual, was Peter Solomon, who was representing SARS in that matter. So it really was sort of a feast of many of the top kind of jurists, if you like. As I say, you're one of the few missing there, Trevor, and that was and it was quite funny to see the constitutional judge being junior to Meyerowitz, and Meyerowitz, as you know, is very succinct in terms of his arguments, and was getting lots of furiously written notes, which he was ignoring, much to the irritation of Mr. Rogers, Owen Rogers, who was sort of his junior in that matter. But yeah, it was a really interesting case. And then it went up to the SCA after
sorry,
that.
I have to add one other thing then, having heard that story, which I didn't know. But there was a case where I wasn't or was I? No, I don't think I was participating. I think I was spectating, because again, I forget who the presiding judge was, but Rogers was on one side and Meyerowitz, with Dennis Davis as his junior, was on the other side. So I knew all the parties concerned. So that's why I had a look. And Rogers had a sore back at the time. And right at the outset of the case, he said to the judge, "My lord, with the leave of the court, may I remain standing throughout the hearing? It's just easier given the back pain that I've got." So the judge said to Meyerowitz, "Mr. Meyerowitz, do you have any objection?" And Meyerowitz said, "I have no objection, my lord, but I don't concede that he has a leg to stand on." Anyway, we could go on forever with these anecdotes. But yes, I very much hear what you're saying. I've lived through some of this stuff.
You certainly have. And just on that sort of unrelated point is the refinancing of existing loans, which is also an interesting topic and comes up quite often. So if a company borrows money and uses it for productive purposes, and then it decides that it wants to refinance that loan, and it goes and borrows new money and repays the old loan, then provided the old loan was incurred or was raised in order to carry on income earning activities, then the interest on the new loan is also deductible. And there's quite a bit of case, or ITC, General Motors case on that. And that comes up quite a lot in practice. I'm not sure that's the case. In fact, I don't think it's the case if a company borrows money to redeem preference shares or preference share funding that was raise in order to carry on income earning operations. And I know there are some other views in the market, but I think there you've got a production of income issue. As to me, it's quite important that the refinancing of a loan refinances an existing loan, which was used for productive purposes. But that's also another sort of interesting area of tax law. And then maybe just the last point to make is, what happens if a company wants to buy a business, but it ends up having to buy shares? So one of the leading cases there, Trevor, which I first heard from you in the 90s in one of your classes, was the Drakensberg Garden Hotel case, where a company leased a hotel from another company and unleased it to someone else. So it paid rent and received rent. And it decided this was not a satisfactory way to go about its business. So it then ended up buying the shares in the company that owned the hotel to secure basically its rights in respect of the lease arrangement. And it borrowed money to do that. And it was held that the interest on the loan was not to acquire the shares and to produce dividend income from them, but rather to ensure the continuation of its rental and trading business. So quite interesting that, if you borrow money to buy shares, generally the interest is not deductible, but that there are factual circumstances that have to be considered, because ultimately it's a purpose test. And now we, of course, have Section 24 capital O, which allows a deduction where a company borrows money to buy shares in a company, provided that the target company is a group company and it is an operating company. So that's been brought into our statutory provision, Section 24 capital O. The practical problem with that, Trevor, that is often the company that borrows the money and buys the shares, yes, it gets a deduction because it's deemed that the interest is incurred in the production of income and for the purposes of trade, but it often doesn't have tax base to set off that interest against, because the activities are at the level of the target entity. So that's often a practical issue in respect of Section 24O and its application. So lots of fun and games when it comes to interest deductibility, I must say.
One thing just listening to you reminds me of, there was a time when it was, I suppose fashionable is the wrong word, but when certain South African companies were buying subsidiaries offshore. And there, if I can put in my own words where I'm understanding what you're saying, one must be careful in this area. And of course, they say you can't get out of the way of what you don't see coming. You need to identify the risky areas and then take steps to. But to the extent that I was involved, which was not much, what these companies were doing were accumulating cash and segregating it, and then using borrowed money to finance their ordinary earning income operations. And then they would use that cash that stockpiled to buy the shares in the offshore company. And then you're not using borrowed money for that purpose.
Exactly. But careful implementation and very careful planning, and the details are really, really important in tax law generally, but especially in those cases.
No, I cannot endorse more than possible what you said. It's one has to identify the issues and take serious advice, and you can save yourself a lot of trouble if you get it right.
I think you had an interesting VAT point you wanted to talk to us about, Trevor.
Yeah, well, I came across something which I found quite interesting, and I hope others might as well, and that's to look at output, the relationship, if any, between output tax from a VAT point of view and gross income. So if you, from using the language of VAT, if you make a supply of goods and you receive, and you're a registered vendor, so what you have to charge, your consideration includes the VAT. Is that VAT part of your gross income? And intuitively, I would always have said, no, it's not. And I came across a situation where a colleague of ours took the other side and said it is, but it's part of what what you've charged and it belongs to you, you might have an obligation to pay something to SARS, but that doesn't stop that from being your income. So in that regard, I would have relied on what was referred to by one of the judges in I think the Friedman case as the benefit principle. So if we go back to the Geldenhuys case, it said you've got to receive something on your own behalf and for your own benefit. There the taxpayer was the usufructuary of a flock of sheep. So the flock of sheep didn't belong to this woman, and the flock was diminishing, and I think she was the widow of a farmer, and so she was farming. And with the permission of the heirs, who were the actual owners of the sheep were sold. SARS taxed the money in her hands, and they said no, it didn't accrue to her, it accrued to the heirs. Even though she had physical control of the money, it wasn't a receipt in her hands. And then there's cases, I won't go through them all. Gen's case, Schreiner said it's not every obtaining of physical control over money that constitutes a receipt. And obviously, if you act as agent for somebody else, it's not your money, it's the other person. Technically speaking, it might be your money in the terms of ownership, but from an accrual or receipt point of view for tax purposes, not. The Minister of Finance versus the Law Society, that was to do with regional services levies. But Judge Goldstone said that monies received by attorneys in order to pay counsel's fees or messengers of the court or correspondence fees or expert witnesses, deputy sheriff, etc., that was not an accrual in the hands of the person, because they were just receiving it to pay it over on behalf of somebody else. And there are a host of cases along those lines. Another one is the Cape Consumers case, where Judge Davis was the judge. So that's a fairly well-established principle. It's not just fairly, it's a very well-established principle. And I would say apply that in relation to VAT. Section 7(1)(a) of the VAT Act says the following: subject to the exemptions, exceptions, deductions, and adjustments provided for in this Act, there shall be levied and paid for the benefit of the National Revenue Fund a tax to be noted. So when you charge that, it's not for your own benefit, it's for the benefit of the and that's what I would have said, and you know, it once became an issue, and in the course of dealing with that, we came across what I found very interesting. The context in which we were looking at this was to do with where a credit provider has sold goods under an installment sale, or for VAT purposes, what's it, a credit agreement. And there's a default situation. So the customer defaults on it. The goods are repossessed in terms of the agreement. That repossession, there are all sorts of deeming provisions. It's a deemed supply. There's a deemed value, and there's so the credit provider can now claim an input tax because he's now deemed to have paid something to that. And all of these deeming provisions have to be looked at, you know, in an integral sort of a way. And what I think threw the cat amongst the pigeons for some people, the National Credit Act says the following: where repossessed goods are subsequently sold, the National Credit Act provides that the credit provider, after selling the goods, must, quote, credit or debit the consumer with a payment or charge equivalent to the proceeds of the sale, less any expenses reasonably incurred by the credit provider in connection with the sale of the goods. But in a situation where you have a repossession, there might well be a loss involved for the credit provider, and not just an income tax loss. So the credit provider might be able to claim a bad debts allowance under it's section 11I or 11J, I always forget which. And the question is whether if the credit provider, if the customer was not registered for VAT, then there's a deemed supply. and the credit provider can get a deemed input tax. And the question is, that benefit that is obtained by the credit provider from the deemed input tax, what was happening in this particular case, that was being passed on to the customer. But I was asking, why must it be passed on to the customer? It's not the customer's thing, and it's VAT. So the issue there was, is the VAT, does it form part of your income? And what's interesting is the following, and not to get too technical here, but it all comes back to this benefit principle. SARS Interpretation Note 48, which was dated the 5th of March 2018, is dealing with installment credit agreements and the debtor's allowance. And if I can read from this interpretation note, it says, it's dealing with the provisions of Section 24 of the Income Tax Act, which says that when you sell something effectively on an installment sale, the full amount of the proceeds are deemed to accrue on the date in which you sign the agreement. And this interpretation note then says the following. Section 24 is subject to Section 24J, linking up with what you were talking about. Accordingly, interest or similar finance charges are not included in the expression, the whole of that amount, for the deemed accrual. Then this interpretation note quotes the well-known passage from Judge Schreiner in Gaines' case and said, not every obtaining of physical control over money or money's worth constitutes a receipt. They quote that. They also quote from the Gelderhuis case. And then the following is said, VAT charged by a vendor or taxpayer under Section 71A of the VAT Act for the supply of goods or services, so-called output tax as defined in Section 1 of the VAT Act, is not received by the taxpayer on the taxpayer's own behalf and for the taxpayer's own benefit. When VAT is charged by a vendor, there is an immediate obligation to pay the amount of the VAT so collected to SARS at a future date. And this is interesting here. Such payment is effected by setting off any input tax or other allowable deductions and paying the balance to SARS. So even to the extent that you set off input tax, that's seen as being a payment to SARS. In these circumstances, output tax does not form part of a taxpayer's gross income. Accordingly, the VAT charged by a vendor does not form part of the expression, the whole of that amount. So for the purposes of Section 24 of the Income Tax Act, the expression, the whole of that amount, therefore refers to the sum of the capital installments, excluding both finance charges and VAT. That's all I wanted to say. I found it quite interesting. Always used to say to the student, the interesting thing about this, and then stop it from him and say, that is if you find this sort of thing interesting. I fully appreciate that not everybody does, but I find it very interesting.
We do, absolutely. I concur with that. That is super interesting, Trevor.
But what you were talking about, that interest and dividends, and that has haunted me for years.
Pops up all the time.
I'm losing sleep about it these days. It's what makes the subject interesting.
100%. 100%. And that's why, although we could talk for hours, we probably shouldn't, because I think our half hour is up. So we'll save it for the next one, Trevor.
Yeah, right. Nice chatting to you as always.
As always. Thanks, Trevor.
Yeah, bye-bye.
Bye.
The Taxpayer is hosted by the editors of the Taxpayer Journal, Trevor Emslie and Peter Dachs. For more information on our journal and other products, please visit our website at taxpayer.co.za. Each of our episodes is CPD certified. To claim your CPD points, please visit our website. Thank you for listening to the Taxpayer Podcast. You can find more episodes on your favorite podcast platform or on our website at taxpayer.co.za. Please like and subscribe on YouTube and rate our podcast on your podcast platform of choice.